The United States Constitution has affected our daily lives for over 200 years. One of the most important amendments to the Constitution is the Eighth Amendment, which prevents the cruel and unusual punishment of those convicted of a crime.
The amendment was originally created to protect the criminals from unfair treatment.
Many cases have challenged this amendment, such as that of Roper v. Simmons of 2005. Simmons, a 15-year-old teenager, was convicted of murder and was sentenced to death. The question was it cruel or unusual to sentence a person who was a minor at the time to death?
Hey, you know what would be a good idea?
What?
Let's tie up my neighbor and throw her in a river.
Okay. You are sentenced to death for throwing the young lady in the river. Just kidding. You were 17. You were too dumb to know what you were doing. Therefore, the death penalty is cruel. Another case that demonstrates this amendment being challenged is Ingraham v. Wright of 1977. In this case, Ingraham, a 14-year-old student, was forced into the office, held down, and spanked by the principal until he needed to receive medical attention. The Supreme Court decided that the Eighth Amendment does not apply in schools.
Hey, get off the stage!
No! But he spanked me. It really hurt.
Sorry, but the Eighth Amendment does not apply to schools. So Mr. Wright is innocent. I don't care that you were brutally beaten. That was the end of that. However, the amendment was challenged once again during Harmland v. Michigan, dating back to 1991.
I'm legally blind.
In this case, Harmland possessed more than 650 grams of cocaine and was sentenced to life without parole. The judges eventually decided that life sentence was unfair and narrowed his punishment down.
I'm not high.
You are sentenced to life without parole for the possession of over 650 grams of cocaine. Never mind, we've decided that a life without parole sentence is unfair, as it is the same sentence given to first-degree murderers, and your sentence shall be shortened.
An early example of a case that affected the Eighth Amendment is Francis v. Resweber of 1946. In this case, a 16-year-old black youth, William Francis, was convicted of murder and was sentenced to death by electric chair. Electricity ran through him, but was insufficient to kill him. In court, he argued that he was protected by the Fifth Amendment and that he could not be punished for the same crime twice, and to do so would be cruel and unusual. However, the court eventually decided that the electric chair was to be repaired and used again on him. I don't think it's working. But sir, they put me through the electric shock. You can't make me go through that again. Well, sorry pal, but we can find no sufficient double jeopardy to get you out of your execution.
I think we've seen enough examples of how the Eighth Amendment is constantly evolving in court. But how does the Eighth Amendment affect teenagers today?
Well, Bill, now that it's been proven that when committing a crime while under the age of 17, one can get off with a shorter leash, teenagers are becoming more reckless and not nice.
I agree.
I mean, just look at the numbers. 32% of teenagers have smoked marijuana by the age of 16. 34% of teenagers have had sex by the age of 16. 45% of teenagers have tried alcohol at least once before they're 16. Teenagers are crazy. crazy. I agree.
So you're saying changes to the 8th Amendment is making teenagers more reckless?
Not exactly. I bet, in fact, most teenagers don't even know what the 8th Amendment is.
Yeah, teenagers are pretty stupid.
So, to sum it up, you can say teenagers are doing more stupid things and will get away with less punishment?
Yeah, that's what I'm saying, yo.
Mm-hmm.
Abraz on fleek.
Swag.